All right. Well, welcome to the webinar. My name is Matt Parker. I'm an attorney here at Marshall, Parker & Weber. We're happy to welcome you to this discussion today entitled Medicaid Myths. I am joined by Patti Turner. Hopefully I'm going to get this slideshow working. Let's see. All right. Give me a minute. Let's see. All right, there you go. I wanted to get your picture up, Patti Jo, so everybody knew what you look like.
Thanks for that. I actually look about 10 years younger than that picture, so.
Patti Jo has been here a long time. I won't tell you how long. But, all right, so during this webinar, we're going to be discussing some misconceptions surrounding the Medicaid program. We'll hopefully get to the heart of some often discussed issues and dispel those misconceptions and provide you the truth for each scenario. Keep in mind, as we go through this webinar, if you have any questions, there is a place where you can type in your question. If you go to webinar Q&A box, and we'll try to provide you a response during the presentation or get in touch with you afterwards. Okay, so let's talk about this fictitious family we've created and that we're going to refer back to periodically as we go through the presentation. So we have the Zevon family. We have Warren Zevon, who's a retired poet. He's age 75. And his wife, Maria. She is a retired school teacher, age 70, and she's in good health. And by implication, Warren's not as in good health as Maria. And we have the Zevon children. So we have Roland Zevon and Johnny Zevon. So Roland's 45, Korean military, moves a few years every few years because of his work, and he's married with 2 kids. Johnny's 43. He's a single guy, operates a local waste management business, and he's living the bachelor lifestyle. All right, so that's your family. Let's talk about the difference between Medicare and Medicaid, because that's probably the most discussed issue that my clients have, particularly when they're concerned about long-term care expenses. So Warren and Maria, they're both concerned about what could happen in the future to them. And Maria's been talking with the ladies at, let's say, the beauty salon, and everybody seems to tell her something different about how those nursing home costs are getting paid. Last week, a friend of hers told her, hey, don't worry about it. The Medicare program is going to cover the bill. And so the first question that Warren and Maria have is they want to know whether that Medicare system is going to cover long-term care expenses. Well, this is the first myth. That if you believe that, you need to take it out of your mind right now because it is not true. Medicare's coverage for long-term care expenses is rather limited. We're going to talk about how limited in a moment. There's another program called Medicaid that often gets confused with Medicare because they both start with M, and that's also known as medical assistance here in Pennsylvania. So if you're medical assistance or Medicaid, same program, and it's that program that covers the room and board in a nursing facility, particularly for those people who are in there for long periods of time. So let's talk a bit about these two programs. And Patti Jo, here's where you're going to jump in and talk a little bit about Medicare and what does it cover if someone's in a nursing home?
All right. Well, Medicare, let's start with the differentiation between that and Medicaid. Medicare is a federal program. It's our government's health insurance program, and it is for citizens who are 65 or over, or sometimes if you're under 65 but you're permanently disabled or certain other circumstances. Medicare will cover some of your stay in a nursing home, up to 100 days of room and board if you meet certain conditions. But not everyone gets 100 days of coverage. I would venture to say most don't get 100 days of coverage.
Yeah, usually they say you plateaued, you stopped improving, and they take you off. So don't think you're ever going to get those 100 days.
Right. The other program then, the people refer to with long-term care stays, is Medicaid or medical assistance. That program is jointly funded partially by the federal government and partly by the Commonwealth of Pennsylvania. It is a means-tested program, so it's not there for everyone. You have to qualify. And there's 2 tiers. You have to qualify both medically, meaning you need the care, and financially. So you need to be in need of the financial assistance that's going to come through the Medicaid program in order to be eligible for these services. It covers the room and board in the nursing home after you become eligible. Most people who are in a nursing home, regardless of what their payment plan was when they started, most of them eventually become eligible for the medical assistance or the MA program while they're there.
Yeah, and that's in part because it costs so much to stay in a nursing home. The average cost per month here in Pennsylvania is about $10,000. So people oftentimes spend down their resources and have to eventually qualify for Medicaid. So I think the first thing that Maria and Warren should be educated about is that if they're going to pay for a long-term stay in a nursing home, it is the program known as Medicaid that they will have to turn to, not Medicare, because not everybody is going to be eligible for Medicare. And one of the things I wanted to point out when we're talking about that is you have to actually have a hospital stay.
Right.
You know, it has to be a 3-day hospital stay, and then in 30 days you are then transferred to a nursing home to even get that Medicare coverage. So it's even less likely that that's going to be a source of coverage for you. All right, myth number 2. So this is probably the second most asked question, if not the first, that I get as an attorney. And it's one that Warren and Maria are concerned about, and that's the protection of their property. Warren's concerned about protecting his guns and money, and he's also particularly concerned about protecting his home. So one of his friends at the Elks Lodge told him there's nothing he can do about it. If he ends up going to the nursing home, the house is just simply going to be taken by the government or the nursing home in some fashion. It's just going to go. So that's the question we have to ask ourselves. Is someone going to take your home if you enter this nursing home, you know, whether you're married or single? So the truth is that a person's primary residence, where they're living, is what we call an exempt asset when applying for medical assistance. And it's not going to be taken away from the nursing home or the government to keep them from qualifying for the program. They just don't come in and say, I'm taking your home, okay? I should point out that there is a program in the Medicaid system where if you get lots of assistance from the government, they could put a lien on your house after you're deceased, okay? So we're going to talk a little bit about that as well. So first of all, we want to explain why this house is exempt or it doesn't get taken when you go and apply for this medical assistance program. And Patty Jo, why don't you chime in?
So there's a whole list of assets that individuals own, and the medical assistance program looks at some of those assets and kind of sets them aside. It considers them to be exempt from paying for the cost of your care. So there is a list that includes primarily your family, your primary residence, but it also includes one vehicle, your personal property, clothing, jewelry, household goods, furniture, burial plots, if you've already got them, irrevocable burial reserves or burial accounts to pay for your final services. Term life insurance is exempt, and that's frankly because it doesn't have any value other than the death benefit. And then the last one, and one of the most valuable exempt assets, is the retirement account of the community spouse or the person who is staying at home. But there are some special rules that apply to this, so you want to be careful when considering that asset.
Okay, so those are the exempt assets, and of course at the top of the list is the primary residence. So what I wanted to point out is that if somebody has a secondary property, we often see this, Patty Jo, they'll have a primary house and then they'll have a cabin or a vacation property, that second home.
Right.
The second home is available.
It is not exempt, just right. The resident.
That's right. Now, there are ways to try and get the second home unavailable, but quite frankly, if it's just a vacation spot, you do have to count that like it was money. So if somebody has an available second home, they may want to do some of the planning we're going to talk about in a moment. But the primary residence is exempt. I will tell you that if you are a single person and you end up in a nursing home, there might not be anybody living in your home. It might be vacant. And consequently, because it's vacant and you're in the nursing home, you may sell the home. So I think that's one of the reasons this has become a myth. They hear about some friend of theirs who ended up in the nursing home and he had to sell his home. The reality is it wasn't the government making him sell, it was the circumstances. It was the fact that nobody's living there and he doesn't have enough money to keep paying the taxes and utilities, so they put it up for sale because there's nobody going to be living there anymore. And I did mention there's this estate recovery program, and I want to talk about that a little bit. If you own your home and you get medical assistance, the government does keep track of the medical assistance they give you. So if you happen to be in the nursing home for over a year, you may get over $100,000 of assistance. If you die, the government does have a right to ask what you owned at the time of your death. The majority of people don't own anything, maybe a small bank account while they're on assistance. But every once in a while, somebody still owns their house. And if that is the case, the government can put a lien on the house, and when it goes up for sale after you're dead, they could get paid up to the amount of the lien from those sale proceeds of the house. So that's a concern for us. And so what we want to do in doing planning, Patty Jo, is we want to transfer that house, hopefully into the spouse's name.
Right.
So Warren goes in, we want to make sure Maria owns the house, or we want to do planning well in advance. And that's really the next topic of conversation. The gifting, the transferring of assets. So we've got a question here about whether to gift assets and what's the consequence of those transfers. We've got Warren and Maria talking amongst themselves, and they're somewhat at odds about what they can do to protect themselves from this cost of long-term care. They've heard a lot of stories from friends, wherever they may be, at the beauty salon, the Elks Lodge, maybe local breakfast hot spots. I think your dad used to do that all the time.
He did. He was a big Donna fan.
So Warren's friends have told him he should just start giving all his assets away to his kids. That way the assets are out of his name, and if he ever needs to go to the nursing home, they'll be hidden. So Maria has heard a lot of different things, though. Her friends have told her, hey, if you give away those assets, the government won't pay the bill in the nursing home. She's heard of something called a look-back period, and is kind of confused. She's really nervous about it. She wants to know what it all means. So this scenario has two parts. Gifting myth part A is essentially what Warren's talking about. Hey, gifting assets away is fine. Just go give away the assets. Once you do, they're hidden. The government will never find out about it. How could they find out about money I gave to my son? The truth is, gifting can protect assets from long-term care, but the timing is so very crucial. Simply making gifts doesn't make them hidden. The government can find out what you did with your money. Trust me. They will look back in time at all your financial records and find out what you did with them. So if you're going to make gifts, you've got to make sure you're doing it at the right time, because there are a lot of issues we need to talk about when giving assets away. Now, part B of this is that if you do give assets away, can you or can you not receive medical assistance? This is Maria's concern. You transfer these assets and the government's not going to pay for your stay. So gifting assets can in fact make you ineligible for medical assistance benefits for a certain period of time. Now the amount of time that you're not eligible is not going to be forever. If you give away $5,000, it doesn't mean you're never, ever, ever going to get medical assistance. There's a calculation to determine how long you're not eligible. Now, if you understand the consequences of the gifting, you get some advice, and you do it early enough, you can, in fact, protect lots of your assets from the medical assistance program and save those assets from being spent on your care. So the question is, how do you go about doing these gifts? If you want to transfer the house, you want to transfer the money, how is it best to go about doing it? And why do we need to be concerned, Patty Jo, about the timing? So why don't you talk a little bit about the rules surrounding Medicaid and gifting?
Okay. The big, hey, heard it at the beauty shop line is about the 5-year look back. Many people are familiar with the term, but don't have a good grasp on what that means. So let's start with the day that you're applying for medical assistance. The 5-year look back pertains to the 5 years immediately preceding that. So you go from your application date back 5 years. That's your window, your Medicaid look back. You have a duty on the medical assistance application to disclose any quote unquote gifts that you've made during that period. Now, the definition of what is a gift is broad. So some things are gifts because they were just given. You gave a $4,000 check to your niece for a wedding gift or a graduation present. That makes sense in terms of a gift. But the state defines a gift as anytime you transfer an asset and don't receive full fair market value. So if you sell a $50,000 piece of property to a good friend for $25,000, you've still made a gift of the difference. So you've made a $25,000 gift, even though there was a purchase on the asset you're talking about. And in terms of how will they ever know, the county assistant's office actually has a right to review your financial records, bank statements, accounts from financial institutions, and sometimes they will ask for records for the full 5 years. So it'll show up.
Yeah, and you know, they scrutinize the records, and anytime they see a withdrawal from your bank account, an unexplained withdrawal, let's say it's $5,000, and quite frankly, nobody remembers what that was for. That's still a gift, because you can't say, I took $5,000 out and I bought something for $5,000, and here's a corresponding receipt for it. They're just going to presume it was a gift, because so many people do try to give money away as they're getting older, whether it's for vacations or gifts for college or otherwise. And so they're presuming in many ways these are gifts, and they add them all up, and they affect your eligibility for medical assistance. And as I mentioned, it's not forever. Generally, under the rules right now, for every $10,000 you give away, you're not eligible for 1 month in a nursing home. It's just a rough estimate, but you get the idea. If you give away $100,000, that's 10 months, and so on. So it's best if you're going to make gifts, you do it well ahead of time. But as we're going to talk about in a minute, there's some early, sort of crisis planning we can do where transfers are still made within the 5 years. Now, I want to talk a little bit about gifting and just make sure if you are thinking about doing this, you're considering some of these issues. First of all, outright gifting to children can be dangerous. We've seen a lot of circumstances where gifts are made to kids and the parents expect those kids to hold on to the money, but in reality, the gifts are consumed by the kids' lives. I mean, whether it's the kids choose to spend the money, maybe there's a divorce, could be financial problems they get into, maybe they have a drug habit, gambling habit, who knows, and the money is gone. And don't underestimate just having a dysfunctional relationship with some of these kids in the future. And it may not be the kids' problem. Maybe it's the people they married, and you've got conflict there. And so just turning over money to kids, generally not the best way to go about planning for yourself. As I mentioned, timing is so very important. Give away assets more than 5 years and you're in the clear. The government just is not going to ask about that house you gave away 10 years ago or the money you gave away 5.5 years ago. So that's obviously the best option for you. If you're going to make gifts during the look-back period, and we as elder law attorneys help our clients do this, we do it on a case-by-case basis. It can be done. You have to do some really creative planning to deal with the fact that you're giving money away and consequently you're not eligible for Medicaid for a period of time. Sometimes we're trying to fix problems where we have gifts that have been made in the recent past and we're trying to address those gifts when we go and apply for Medicaid. It's often best not to run out of money and then realize, oh my gosh, my mother gave away $50,000 5 years or within the last 5 years. That's a problem. So go see an elder law attorney while you still have some money, and hopefully those gifts made within the look-back period can be addressed. Irrevocable trust. If you're going to make some transfers of assets, again, 5 years ahead of time, one of the popular ways to shelter them is to use a trust. And these trusts are asset protection trusts. They're intended to protect your money or property from the cost of long-term care. So you can transfer your home to an irrevocable trust. You can transfer excess available money, so you don't have to spend down as much if you ever enter a nursing home. You get some really nice tax advantages. You get some tax savings on what we call capital gains tax. You can protect assets in a trust from all those problems with the kids, like the divorces and lawsuits and falling out with the kids, because with a trust, you haven't really given anything to them until you pass away. And you can also control the distribution of death. A trust, like a will, disposes of your money and property in the trust when you pass away, and you can divide it up in percentages, or you can leave so much to a child in a trust, like a special needs trust if they have some problems, or You can leave more to one child, less to another. So all those things you can do in your will, you can do in your irrevocable trust. So that's a popular way to shelter assets if you're going to do so. And I obviously strongly recommend it because I don't know what families are going to have issues and which ones will not. So we've got myth number 4. We're too late. So Warren and Maria have just not gone ahead with any planning. They were going to, but then, they just couldn't make a decision about what to do. Warren didn't want to give up his guns and money. And so the couple didn't get around to doing anything. Warren's health takes a turn for the worst. Maria has tried to take care of him at home for as long as she could, but she can no longer do it. After a brief hospitalization, Warren's discharged to a nursing facility. He's not going to be able to go home. And his Medicare days are running out. Like I said, there's only at most 100 days, and so those are coming to an end. Maria comes to the law firm of Marshall, Parker, and Weber, and she wants to know what can be done. She's sure it's too late because those folks at the beauty salon have told her, nothing you can do. Once the spouse is in the nursing home, there's no planning to be done. You're going to have to lose all of the money. So the reality is that there is planning that can be done even when someone's entering a nursing home. This is the big area that elder law attorneys get into. It is possible to protect the assets even after somebody enters the nursing home. In fact, the non-nursing home spouse, who's often called the community spouse, has lots of protections. In this case, Maria is going to be able to keep a lot of her resources. So, Patti, Joe, what are the rules protecting Maria when Warren enters that nursing home?
Well, to start with, after looking at all of the available assets, 50% of them can be put aside as the community spouse's resource allowance. Of course, that 50% is subject to a maximum, but they can keep 50% up to the maximum. They have their own IRA or 401k, which is exempt from the cost of their spouse's care in Pennsylvania. And the community spouse's income, whether it be her Social Security or her pension, and I say her because it's Warren who's in the nursing home, but her income is also protected from the cost of his care, so she gets to keep that. There's also a minimum monthly maintenance needs allowance, which is a mouthful, but it's there to help protect community spouses who have low income. They can have to meet a threshold of a minimum income level, and sometimes that means that they are getting money diverted from the nursing home spouse as well to help bring them up to that level. The availability of the exempt resources also get to be kept, of those things we talked about, like the car and the life insurance policy, one car, the burial plot. All of those things also are protected. In addition, there are additional planning that can be done with additional resources that we haven't dealt with in this list yet. Excess resources can be spent down on items that either spouse might need. And then there are specialized annuities that can be used to convert excess resources into income for the community spouse. So there's a lot of quivers and arrows in the quiver that will help the community spouse stay afloat.
Yeah, and I just had a case where the county assistant's office had told the client, hey, you got to go see an elder law attorney about this spousal annuity that can be used to help protect excess resources. Because normally, if you can only keep 50% of the money, a lot of times there will be a spending plan to try and reduce the resources so you can become eligible. And it's okay if you just have to spend a little bit. They might set up burial accounts, maybe buy a new car to become eligible for assistance. But a lot of times there's a lot of extra money, and you can't spend it all. $100,000. Oh, what am I going to spend it on? So you set up one of these spousal annuities that can convert the excess money into annuity payments for the community spouse. So in this case, let's say Maria had way too much money, and to get Warren eligible for assistance, that she could come to see the elder law attorney at Marshall, Parker, and Webb, and set up one of these spousal annuities for herself and protect that money for her rather than spending it on the nursing home. So all of these protections are out there, the resource protections, the income protections, as well as these planning opportunities. So in a married situation, you can also protect a lot of money for the community spouse. So don't think there's nothing that can be done. You can always turn to a good elder law attorney to preserve those resources. Well, we've reached myth number 5. So can children be responsible for the parents' care? So Warren has passed away. Maria has outlived him, and she lived independently for quite some time. But now she's going to need nursing home care. And now during her lifetime, she was very, very generous in making gifts to Roland and Johnny. So she doesn't have a lot of money left. Now Roland, well, he's not behaved as responsibly as she would have hoped. He's become a gambling addict, and he's blown through a lot of the money that Maria has given him. Now Johnny's been helping Maria, but the waste management business hasn't been going so well, so he's gotten some gifts as well from Maria. So both of these guys have gotten gifted money within the last 5 years. So Maria's now in a nursing home, and she's running out of money because she's given most of it away from her kids. Could those kids be sued by the nursing home to pay for Maria's long-term care expenses? Well, the reality is that under Pennsylvania's filial support law, they could be liable to support their parent, Maria in this case, financially. They could be sued by the nursing home if the nursing home is not getting paid because of the gifts that Maria made. So what's this crazy law all about, Patty Jo?
Well, filial support is the name of the crazy law. It's actually an old law that's been on the books, but was recodified in the not too distant past, meaning it's been brought back up and made active. The filial support says that children have a duty to support their indigent parents, meaning if the parents can't provide for themselves, then the children are expected to chip in. Nursing homes are the ones who've been using this law, and they're using it as a means of debt collection. When they're not getting paid otherwise, this is one way that they're trying to go after a payment for the services that they've been providing. Now, the good news is a proper medical assistance application is usually the answer to the filial support conundrum. However, there are still issues when a penalty period might occur, but the gifted funds are no longer there or can't be returned. So the moral of the story is that caution is always your friend and should be exercised when you're considering gifting, and professional advice should always be sought out, like at Marshall, Parker & Weber.
There you go. So in this case, Maria was being a little irresponsible with her money because she was getting older, possibility of nursing home care was there, and she just kept giving away to these needy kids. And so she's run out of money, and the money is gone because Roland spent it all. And even if Johnny hasn't spent his money, the nursing home more than likely is going to sue both of them. Right. You know, it doesn't matter who got more or less or who even got any of the money. They just sue all of the kids. So they can sue the kids to help pay the nursing home bills if you're not eligible for medical assistance and the nursing home is being stuck with a bill. So here is the conclusion to some of our findings today. As we mentioned, Medicare is limited in terms of its coverage of long-term care costs, and Medicaid's the big program that people are using. The government really doesn't take your house when you enter the nursing facility. There is an estate recovery program where they put a lien on the house at the time of your death, but they don't force you to sell the home during your lifetime. Gifting can be done. It's a really powerful tool to protect assets, but use some caution. If you gift within those 5 years, that could affect your eligibility for assistance, and do consider using trusts to protect assets to avoid a lot of those issues with outright transfers. There are plans to protect assets even when one of those spouses enters a nursing home. A lot of great advice can be given to a spouse to preserve the resources that remain. And lastly, children may be liable for a parent's long-term care expenses if they've mismanaged the money within those 5 years and they're not eligible for medical assistance. So I appreciate everybody turning in. If you have any questions, don't hesitate to email or send those to us, and we'll certainly get back to you. We appreciate the time you took to listen to Patty, Jo, and I. Take care.
Have a good afternoon.